Monsieur le Président, Monsieur le Secrétaire général, permettez-moi tout d'abord de dire à quel point j'ai le plaisir et quel est l'honneur que je ressens d'être parmi vous aujourd'hui, et je remercie très sincèrement UNIDROIT d'avoir bien voulu associer la conférence de la Haye aussi à ce grand moment que nous vivons. Et sans plus tarder, je tiens au nom de la conférence de la Haye à souhaiter un joyeux anniversaire à UNIDROIT et féliciter UNIDROIT, ses membres, son secrétariat, tous les experts qui ont grandement participé au succès, au grand succès, nombreux succès de votre organisation, et dire à quel point on se réjouit de continuer à travailler avec vous sur plusieurs domaines et par rapport à plusieurs projets. Permettez-moi aussi de dire que de la Haye, nous vivons des moments très agréables avec Rome, avec UNIDROIT, dans la mesure où, sous l'impulsion, la vision de son secrétaire général, de son président et de toute l'équipe du secrétariat, UNIDROIT a 90 ans, plus que jamais, est jeune, dynamique et tourné vers l'avenir. Bref, notre petite sœur, si je puis dire, se porte merveilleusement bien et je vous en félicite. This brings me naturally to the topic of this last panel, which is on civil procedure and international cooperation, which is obviously one of these fields where the work of the Hague Conference and of UNIDROIT meet. This is one of the crossroads. Suffice to say that for UNIDROIT we are talking, for example, about the principles of transnational civil procedure that UNIDROIT has developed in cooperation with the American Law Institute, adopted in 2004. There is the ongoing UNIDROIT and European Law Institute initiative developed with a view to developing a regional set of rules of European civil procedure. We are glad to participate in this process as well. I know that we'll hear more about this in a moment. And then there is also future work where, first of all, the two organizations, Hague Conference and UNIDROIT, would like to present their relevant instruments in a more systematic way to make the practitioners, to make courts, to make the public in general benefit more effectively of these various instruments and explain them to them. And then hopefully also with a view to adding a link that is often missing in the international civil procedural harmonization work, which is actual enforcement, because all these civil procedural rules are very nice and very good and important, but at the end of the day, if you cannot actually enforce your judgment and get your money or have your opponent stop what he or she has been doing, it's actually not worth much. So the enforcement package or element is certainly very important as well. Inside of the Hague Conference, of course, there are various conventions that deal directly with transnational civil procedural issues: Service Convention, Evidence Convention, Access to Justice, Choice of Court, Judgments Project, Take Two, BIS, whatever you want to call it. That is ongoing work, but then also in the family law side of things. We haven't talked about family law at all today, but even a child abduction convention, of course, is very procedural in nature, or the maintenance convention of 2007 has a lot of procedural elements for the effective recovery of maintenance obligations abroad. That's really enough from the chair. I am delighted to be on the podium here with three distinguished experts. I will start with Ms. Karin van der Kerkhoven, acting head of unit at the DG Justice and Consumers, a big DG as we all know. She will actually start because of logistical reasons and flights that have been cancelled and this and that. We'll then continue with Ms. Diana Wallace, President of the European Law Institute, and then, last but not least, ask Professor Jan von Hein from Freiburg in Breisgau to talk to us. Brussels, Vienna, Freiburg, a bit of The Hague. I don't want you to think that this is a purely European panel. It's not. If you look at the CVs of my distinguished colleagues here, they all had a lot to do with outside Europe, either in terms of their education or indeed their professional experiences. Without further ado, I would like to ask Ms. van der Kerkhoven to give us, I understand, a EU perspective on the importance of transnational civil procedural law. Please, you have the floor, Karen.
Okay, thank you. Good afternoon to everybody, and many thanks to the organizers also on our side. Happy birthday to the organization, to all the staff making this organization a dynamic organization. Now, and thank you for having invited us, and thank you for organizing this panel. It may be a bit difficult after the high-level discussion on big principles such as rule of law and social responsibility to come back down to earth to civil procedure. But nevertheless, civil procedure, even if it is as old as our legal systems are, civil procedure is a very, very lively topic. And I think the chairman already mentioned so much work that is ongoing currently in the area of civil procedure. UNIDROIT itself has started already quite a while ago on civil procedure. In 2004, there were the ALI, the cooperation with ALI on the transnational principles of civil procedure. There is the work ongoing now with the European Law Institute on Civil Procedure. The Hague Conference also, in the end, it's about civil procedure overall. And at EU level, we try also to work and we have a substantial set of rules and instruments on procedural rights. Now, why all this focus on procedural rights? Well, procedural rules really are at the heart of a fair and effective judicial system. They fulfill several roles, but probably their main role is to ensure the protection of the rights of the parties. And particularly in the context of procedure, the rights of the parties to be protected are not only the rights which parties are granted under substantive or material law, but really the manner in which they can enforce such rights. And so the enforcement of rights is at the heart of two core fundamental rights which are recognized in the European Convention on Human Rights: access to justice and the right to a fair trial. And so from that perspective, I will focus on what I know best is these procedural aspects of the enforcement of rights at EU level. And I hope that this perspective can further inspire the work which is ongoing in UNIDROIT and the European Law Institute on procedure. Now, from the EU perspective, really, the fundamental rights of access to justice and fair trial are guiding the development of justice in the development, rather, of the justice area, which we try to set up at EU level. Because in designing and developing the procedural rules at EU level, the main driver is the wish to ensure effective and speedy access to justice, which is the topic of the subpart of this panel. Indeed, the saying goes that justice delayed is justice denied, and therefore the development of effective and speedy procedures is crucial to ensure access to justice. Let me give you a few examples of how, at EU level, we strive to establish an effective and speedy civil procedure. I could give many examples, but I only pick out a few. Common rules on legal aid ensure that parties have access to justice and are not hindered in exercising their rights cross-border. Effective access to justice, indeed, could not exist if parties don't have the financial means of enforcing their rights. But it's not only about financial means. As you know, at EU level, we have a system, and some of our neighboring countries, like Switzerland, Norway, and Iceland, participate in this, but we have a system where we allocate jurisdiction of the courts among member states. Why we do that? It's in order to ensure that defendants are sued in a jurisdiction which is foreseeable for them and which is fair. So it's about fairness, about effective access to justice. But it's not only about effective access to justice, it's also to avoid that parties need to litigate twice. Because it may very well be that you have access to justice in a certain country, you obtain an enforceable judgment, and you arrive in another country which does not want to recognize your judgment because that country considers that it should have dealt with the case, or its courts should have dealt with the case themselves. So common jurisdiction rules avoid these delays, these costs, and are therefore important in ensuring not only fair, but also speedy justice. And at the same time, then, we have seen in the EU the development of this element, because we have realized that the strict allocation of jurisdiction among member states of the European Union really requires that each state lives up to the requirement to deliver a speedy and effective justice. Because if a state does not deliver on this point, there is a risk that the rules, the jurisdiction rules, for instance, but also other rules, are abused by parties to delay justice. And that's why, even if it's very difficult as a question of competence, definitely, why we have started work in the European Commission since a couple of years to monitor the operation of national justice systems of EU member states. And speed and efficiency are among the key criteria, really, which are considered in what we call, in the jargon, the judicial or the justice scoreboard, which aims at stimulating developments in this matter. So clearly you see that what was from the very beginning a real internal market-driven development of allocation of jurisdiction to support businesses, to create a support for the internal market, has developed gradually into also looking into the efficiency of national justice systems. Another example, and I think it's the same as the example mentioned already by the chairman, common rules on service of documents. They ensure that parties have an effective opportunity to defend themselves and are not the victim of the uncertainties in cross-border transmission of legal documents, or suffered from the fact that documents are established or drawn up in a language which they do not understand. So again, fairness, effectiveness, and access to justice. But not only that, again, there's also an element of speed in there. Common rules on service of documents in the EU have, at the same time, substantially reduced the time required for cross-border service of documents, and we have statistics showing this. Now, if something were to go wrong and parties would not be aware of proceedings ongoing against them in another state, common remedies exist for defaulting defendants to ensure that their rights of the defense are respected. Uniform procedures, in particular for uncontested and small claims, aim at removing obstacles to justice which exist due to the differences between member states' legal systems. The uniform procedures, which we have at EU level, ensure a speedy and effective recovery of claims in cases where the lack of access to justice is particularly difficult to accept. This is the case in situations where a defendant doesn't even contest the claim, or in situations where the claim is so small that the parties or the claimant will easily forego its rights by not pursuing their enforcement. Finally, I know that in this whole day and in the UNIDROIT in general, the focus is more on the commercial law, but I would like to follow the example set by our chairman to refer also to the family law, where procedural law is crucial. One element that I can mention, for instance, is the hearing of children in family law matters, crucial in the system of cross-border recognition and enforcement of decisions in family law matters. And procedural rules in this area touch on several fundamental rights, such as also the right to a private and the right to a family life. So I have given you a few examples, but we continue to have a critical look at the effectiveness and the speed of civil procedures. And now I look a little bit forward and I give you some examples of the issues which we are currently looking into. And one such area really is the family law area in matters of parental responsibility. As I just mentioned, civil procedure is crucial in order to protect the right to private and family law. In family law, time is even more of the essence to protect the fundamental rights of the parties. The right of a parent to see his or her child, the right of a child to maintain contact with both parents. An evaluation of our existing instrument in this area has shown that speed, as far as speed is concerned, all goes relatively well in order for parties to obtain a judgment and in order to ensure recognition of a judgment abroad. However, matters get stuck once the judgment must effectively be enforced. The real pure enforcement procedures, which until now remain very largely governed by national law, often do not take into account the specificities of family law and allow for endless protraction and delays caused by an unwilling parent. Now, it's unacceptable that parties can delay procedures in such a way that enforcement of a judgment becomes basically meaningless or can even be against the best interests of a child. If a child has been removed from one parent and has been living for 5, 6, 7, some 10 years away from its other parent, it becomes questionable whether a judgment that orders the return of the child should still be enforced. So we have an upcoming revision of this legislation, and we will, in the near future, make proposals to at least try to remedy such situations. A second focus that I would like to mention, also forward-looking on procedural rules in the EU, concerns the basis for the civil justice cooperation in the EU in general, which is the free circulation of judgments based on a big principle, which is called mutual trust. Clearly, evidence shows that mutual trust cannot exist without a full respect for the fundamental rights. Now, all EU member states are parties to the European Convention on Human Rights, and so all cherish the respect for fundamental rights. Nevertheless, when looking at civil procedure, we should be humble and recognize that our legal systems have developed since a long time and in various ways. Some rules and institutions may have developed in an era which looked differently at certain procedural questions, and they may be regarded differently today, and they are definitely regarded differently in different member states. From this perspective, we are carrying out for the moment a very large study aimed at detecting which are the crucial elements in civil procedure that ensure mutual trust. Or perhaps I should formulate it negatively. Which are those elements in civil procedure which are an obstacle to mutual trust and therefore to the free circulation of judgments within the EU? It's a very broad study, an all-encompassing study over the entire civil and commercial area. The results of this study will be available by the end of this year, and on the basis of this study, we will then decide whether it would be appropriate to undertake further action to strengthen procedural rights in the EU, knowing that, of course, apart from the legislative side, also the European Court of Justice does play a very important role in strengthening procedural rights at the EU level when interpreting EU legislation. So in this context, we are definitely very eagerly following the work which is carried out by UNIDROIT and the European Law Institute on the rules of civil procedure. And we are convinced that it will undoubtedly inspire future work at the EU level. Thank you.
Thank you very much indeed, Ms. van der Kerkhoven, for this very complete overview on the importance of the procedural rules in general and on the various initiatives taken or about to be taken at EU level. I know, Ms. van der Kerkhoven, that you will have to leave at one stage, so I invite the audience, if you have a question for Ms. van der Kerkhoven, then please raise it now, before it is too late. If not, then you just stay for as long as you can, and then maybe we can take questions later on. Then I would like to turn the floor to Ms. Diana Wallis, President, European Law Institute. Please.
Thank you very much, Chair. Thank you very much to UNIDROIT for inviting the European Law Institute to participate in your celebrations. I would like, very much like every other speaker, to say happy birthday. I'm sorry that Karen has now to go, but in saying happy birthday, it occurred to me, sitting in the audience, obviously you can hear I'm British. We have another birthday today. It's our Queen's birthday. And there were many pictures in the British newspapers that I saw on the plane coming over of part of our royal family. So the Queen, Prince Charles, Prince William, and the tiny Prince George, who had to stand on a stool. Well, I think the European Law Institute, in relation to UNIDROIT, feels a bit like Prince George, the toddler stood on the stool. So thank you very much for including us. We are at the beginning of our journey, but we're glad to celebrate with you today. Now, the subject of this panel is effective and speedy civil procedure as a human right. I think I would have preferred the words effective and efficient. I'm not sure that speed as such is always the answer. We want procedures that really work well. And I want to put my comments into two parts. Firstly, just some general reflections maybe about the title, and then to speak in much more detail about the joint work that ourselves as the European Law Institute and UNIDROIT are doing in this area of civil procedure. Firstly, for some just very general reflections really about the title, clearly it's already been explained the importance of good civil procedure to making things function and delivering access to justice. And that must surely be our concern, to make sure that commercial entities, that individuals have access to justice and they can enforce rights. And we're not here in terms of human rights, of course, talking just about constitutional rights, rights against the states. We are very much talking about private economic rights, all sorts of rights where we need state courts to act both as an umpire and as an enforcer, which has also been mentioned. So this right to an access to justice and the way in which civil procedure is able to deliver that for us is hugely, hugely important. And as has already been said, our rules of civil procedure have grown up in our national traditions of law, in our various national boxes. But for those that don't know me, I spent 12 years in the European Parliament, mainly dealing with civil justice issues. And the thing that we always wanted to try and do was to make these things work in a cross-border context and work effectively. And it's always very, very difficult. And I think our speaker from the Commission gave us a hint of this, because of course this area of civil procedure is very sensitive, very much the preserve of member states. And already we see, you know, many member states, I would say my own included, but we're always difficult, doesn't like the European Commission's Justice Scoreboard. So these areas are sensitive and they are difficult when it comes to trying to use what I would call a sort of substantive legal rules, normal tools of harmonization. Can we find other ways, can we find softer ways to try to make our various civil procedures in a national context mesh in an international way to deliver cross-border justice, which is, after all, what most of our commercial entities and many of our mobile citizens now require of our legal systems. So where does the European Law Institute fit into all of this? Well, as some of you will know, UNIDROIT undertook work with the American Law Institute some years ago and produced principles of transnational civil procedure. Now, the American Law Institute is the institute upon which our European Institute is modelled. For those of you that don't know what that model involves, let me take a moment or two to explain. What we try to do as an institute is to bring together the various elements of Europe's legal community. So practicing lawyers, judges, academics, many other legal professionals, be they bailiffs, notaries, all sorts. And we don't come together as many of the legal organizations come together to lobby for a certain professional interest or a certain point of view. The idea is that you bring the legal community together to benefit from its distilled and joint wisdom to try to improve the nature of European law, to work on projects, to work on issues where we can put something on the table and say to the European institutions and perhaps the wider world, look, here we, Europe's legal community, think there is perhaps something that can be done. The American Law Institute has been tremendously successful in doing that. We are in our early days, but we make progress. So we thought, having seen what had been done by the American Law Institute and UNIDROIT, that perhaps here was a chance to do something in a European context, where there is already this sort of feeling that within the hard structures of the European Union, you bang up against national sensitivities. Perhaps you can do something in a softer way by using the ALI UNIDROIT model, produce some transnational principles and rules of civil procedure that may be helpful to the legislator, may be helpful to the judiciary. Who knows where the end result of our work will go? But that's the idea. Where are we? Well, we are, I guess, now about 2 years into our work. We have a number of working groups on different issues of civil procedure. We have involved a huge number of academics and others, some that were involved in the original ALI project. And indeed, after this meeting here today, our steering group is meeting tomorrow and the day after. And what I want to try and do is, without preempting any end result, because I couldn't give you the details of what we are going to finally propose, to give you just a flavor of 2 areas from 2 of the working groups where I think we could maybe help, we will maybe make a difference. The first is in relation to service of process or service of documents. Now, clearly the European Union and its institutions have already done work in this area. But, you know, one of my regrets was always that we were never able to sufficiently harness the possibilities of new technology alongside the sort of borderless area that is the European Union. So how can we do this in civil procedure? Well, obviously, we want to move towards some sort of rules or principles that would allow us to use electronic service of documents across border. But in doing that, to find a way that will properly respect the rights of the defense and respect the balance between unequal parties in a procedure. So our working group in that area is beginning to work to formulate a principle or rule where you ask any commercial entity, and I use that in its widest sense, to be on a register and to be available to accept electronic service, and the same with lawyers. So that party would have an obligation, if you like, but for individuals, you don't do that at the moment. So you have a sort of balancing mechanism, but you move towards a position where you take advantage of new technology. It's just to give a flavor of the sort of thinking and the way that we are trying to move things forward. If I look at another area, one of our other working groups is looking at the so-called obligations of the parties in civil procedure. Now, clearly this is hugely difficult in terms of our different cultures. You know, I'm a common law lawyer. I grew up in what is a very adversarial process. Civilian tradition is quite different and basically investigatorial. How do you bring these very, very different processes together? I remember as a young lawyer, you know, I was based in London and I spent a huge amount of my time explaining to clients from France, from Belgium, from Germany, this strange animal that was English procedure, that was so different and so alien to anything that they had encountered before. So how do we bring those two worlds together? Well, the way our group is thinking about that is to have, as it were, a notion, an idea of loyal procedural cooperation that means that the court, the lawyers, and the parties have to work together. They all have a common aim to get the dispute resolved in an efficient way. So if we bear that in mind, they should all be prepared to sign up to some sort of notion of loyal procedural cooperation that can cut through these huge differences in our cultural legal traditions. I'm just giving you a flavor. I'm not giving you the rules. That will come from our experts in due course. But the whole idea of this, as I say, is to try to find a softer, more acceptable way of breaking down these barriers between our different legal traditions without intruding too much upon them, but at the same time delivering what we know is required in our modern world, a system of access to justice across borders that really delivers effective and efficient access to justice. Thank you.
Thank you very much, Madam President. Really highly interesting and thought-provoking intervention. Turn to the future, use of new technologies, redefining basically transnational civil procedural law for a region, maybe. Topics that are very much on the agenda to some extent of the Hague Conference as well. Needless to say that we will continue to take an active part in your work as well and closely follow its development. Thank you again. I think at this stage is actually quite a nice transition to Professor von Hein's presentation, because I understand he will be focusing on the classic topics of civil procedural law, on evidence in particular, and maybe a little bit of service as well, but talk to us also about the use of new technologies, and then the hot topic as to the mandatory or not mandatory nature of some of these instruments. Please, Mr. Professor, you have the floor.
Thank you. Okay. Thank you, dear presidents of the Governing Council and the European Law Institute, dear Secretary Generals of UNIDROIT and the Hague Conference, dear colleagues, ladies and gentlemen. Dr. Bernasconi has already said it. I'm going to talk a little bit about everything because, no, I'm not going to do that, because the subject was rather widely framed, judicial cooperation in civil and commercial matters. But there's one thread running through the presentation, or at least I hope that there's a thread running through it, and this is the complex relationship between treaties and regulations dealing with judicial cooperation in civil and commercial matters on the one hand, and soft law instruments, principles of procedure on the other. In order to shed some light on this intricate relationship, I'm going to give you first a rather basic survey of some fundamental notions and issues involved in judicial cooperation, the pertinent legal sources and the institutional actors participating in the various legislative processes, and I will then come to the more or less classic problems in the light of new technologies. Well, as Ms. van der Kerkhove and Ms. Wallace have just said, there are varieties of judicial cooperation. The TFEU uses a rather wide concept and contains this enumeration of various kinds of judicial cooperation, ranging from mutual recognition of judgments to the training of judges. The Hague Conference traditionally has a rather narrower focus in the Hague legal parlance. The legal cooperation conventions usually refer to the Service and Evidence Convention, as well as to the Access to Justice Convention and the Apostille Convention. Of course, this is not to say, Ms. van der Kerkhove has stressed this already, that the other Hague conventions have no elements of judicial cooperation. Of course, the Child Abduction Convention or the Convention on the Protection of Children or Adults have significant elements involving the need for judicial cooperation among the contracting states as well. But nevertheless, in what follows, I will consider the gathering and transmission of information as the centerpiece of mutual legal assistance, and in this field we face three common challenges. The first challenge is a continuous multiplication and interaction of different legal sources, making issues rather difficult for practitioners. Then the classic problem whether judges are free to have recourse to one of the instruments at hand, or whether they are actually obliged to apply them under certain circumstances. And finally, new technologies and their impact on this classic problem. If we look at our subject from a private law perspective, we see a kind of triangle of legal sources. On the one hand, we have global conventions on judicial cooperation, namely the Hague Evidence and Service Conventions. At the other side, we find regional instruments on judicial cooperation. Of course, with this I refer to the EU Service and Evidence Regulations. And finally, we have some principles on procedural law, soft law, for instance, the ALI UNIDROIT principles on transnational civil procedure. This triangle of legal sources is reflected by a triangle of institutional actors. We have the Hague Conference, the EU, and UNIDROIT, ALI, and ELI on the other hand. And this triangular relationship may create some problems in daily life. Triangular relationships are complicated, and we'll look at the problems involved in this relationship here as well. No legislator, no institutional actor in this triangle is working in isolation. There are significant overlaps and interactions between the activities of the institutional actors. First of all, it is obvious that the EU service and evidence regulations are visibly influenced by the model of the Hague Conventions. Of course, they are modernized versions, they are much younger instruments, but with regard to the basic structure and the formulation of rules, we still see a visible impact of the older or earlier Hague models. It is questionable whether this has an impact on interpretation. Of course, the Court of Justice of the European Union, it is well known, prefers the principle of autonomous interpretation and does not openly have recourse to materials relating to the Hague Conventions. Moreover, the competence of the CJEU is so far limited to the EU regulations because these older Hague Conventions are classical multilateral conventions concluded by the member states themselves and not by the EU as some newer Hague conventions. Then we have a second relationship that is between UNIDROIT on the one hand and the Hague on the other. Rolf Stirner, my colleague from Freiburg University, has written in his commentary on the ALI UNIDROIT principles that they could serve as guidance for courts when they have to apply the evidence convention. So there's a kind of supportive role envisaged for the UNIDROIT principles in regard or with regard to the evidence convention as well. At first, this sounds like a rather clear-cut division of responsibilities. The Hague legislates or conventions or creates conventions, and UNIDROIT and the ALI delivers some supportive soft law, but this relationship is also more complicated than it seems at first, or than it might seem at first, because the Hague Conference has lately ventured into the business of promulgating soft law as well. If we look at the principles of choice of law and contracts, and of course, as you all know from other fields than civil procedure, there are some conventions, some rather successful conventions, created under the auspices of UNIDROIT. So it's not such a clear-cut relationship, perhaps, between these two organizations. And then there's the third strand of this relationship between the EU, or the ELI, as an institution closely affiliated with the EU, and UNIDROIT. With this, of course, I refer to the ELI, UNIDROIT Rules of European Civil Procedure, and their rule in this triangular relationship. So that's the private law perspective. If we look at constitutional and human rights, we find another triangle. So we have two triangular relationships, and this is between various legal sources on human and fundamental rights that might have an impact on the interpretation of legal instruments on mutual judicial assistance. First of all, the Convention on Human Rights, then the Charter of Fundamental Rights in the EU, and of course rights flowing from national constitutions as interpreted by the constitutional courts. As Karen van der Kerkhove has already mentioned, the constitutional and human rights constraints are particularly visible in the field of parental responsibility, paternity, adoption, all kinds of scenarios where the welfare of the child is at issue. And you find here just 3 references to recent case law of the European Court of Human Rights, the Court of Justice of the European Union, and most recently the German constitutional courts, and all courts have stressed the constitutional right to an efficient and effective gathering of evidence in paternity suits, suits involving parental responsibility, and a case relating to adoption. In all these cases, the welfare of the child demands that the court uses the most efficient and effective means to gather evidence. On the other hand, the constitutional right to obtain evidence as efficiently as possible must, of course, be in all cases reconciled with the rights of witnesses, the rights of the other party. That was the issue, for instance, an interesting English decision, the 3 Mile Inn, where the English party wanted to take evidence to depose a witness who was at the time hospitalized in Monaco, but the ill party refused and claimed that he had a right to attend the trial in person, and the court, based on this objection, refused the right to obtain the evidence by video link, a rather interesting decision. Moreover, rights of third parties, issues of data protection, and rather old-fashioned but still alive concerns of sovereignty may play a role in this regard. So, short sum, in between, we have a dilemma for our domestic judge. On the one hand, he enjoys, or she enjoys, a rather wide discretion to choose among various legal sources, domestic law, Hague Conventions, EU regulations, soft law principles, and on the other hand, we have growing constraints from a constitutional law perspective which stress a party's right to obtain evidence. In this predicament, our poor domestic judge would be glad if he or she would be offered, were offered some kind of guidance, and in the remaining parts of my presentation, I will look at the role that soft law can play in giving judges this kind of guidance. As you will probably know, there is a classic controversy surrounding the issue as to whether instruments on mutual legal assistance have an optional nature or whether they are of a mandatory application. This issue has been discussed both with regard to service and evidence. I will focus mostly on evidence here in this presentation. There are basically 3 alternative routes to obtain evidence in an international dispute. First of all, a court may, if its domestic law allows it, transfer evidence from abroad to the forum state. It may seek active judicial assistance by a requested court, or if a convention or regulation allows for this method, it may also proceed to a direct taking of evidence if the requested state permits such activity of judges, court-appointed experts, or other supportive personnel on foreign soil. The classic leading case in this regard is still the aerospatiale decision of the US Supreme Court, in which the Supreme Court famously, but not undisputedly, decided that the application of the Evidence Convention is not mandatory, and that there is no duty of first resort to the Convention as a result, US courts may rather freely have recourse to their own domestic procedural methods of gathering evidence, and as a practical result, they rather rarely use the evidence convention at all. This has been criticized from European states and other mostly civil law states parties to the Hague Evidence Convention. However, the EU evidence regulation insofar seems to follow the same basic approach, and this has in recent years been confirmed by the Court of Justice of the European Union. In the Lippens decision, the Court of Justice stated that as a matter of principle, the European regulation does not block faster procedures available under a court's domestic law. So here the Court of Justice stresses the importance of speed with regard to mutual judicial assistance. The court said that the competent court of a member state has the option to summon a party that it wishes to hear as a witness and hear him in accordance with the law of that member state without having recourse to the evidence regulation. In my opinion, this result is in this specific case correct, in particular when one takes into account the special procedural relationship that exists between a party and the state of proceedings. Moreover, the actual deposition of the party is performed in the forum state and not on foreign soil, so this is quite a defensible decision. The problem then, of course, arises: where is the line to be drawn? Particularly with regard to the direct taking of evidence. Does this mean that a court can now send foreign judges abroad or send court-appointed experts abroad? This issue arose in the next leading case decided by the CJEU. This is the widely discussed ProRail case, in which a court wanted to send an expert abroad to the Netherlands to gather some evidence there. The problem is that there is a procedure for such a scenario envisioned in the evidence regulation in Article 73, but the question, of course, was, is a court obliged to have recourse to this procedure? Is it obliged to ask the requested state for permission in order to send a court-appointed expert, or may it simply dispatch the court-appointed expert under its own domestic law? And the rather unclear answer of the Court of Justice was not necessarily. So the domestic judge is not necessarily required to use the procedure envisaged by the evidence regulation. The main arguments of the CJEU again relate to the issue of speed and effectiveness. In certain circumstances, the court argued it may be simpler, more effective and quicker for the court ordering such an investigation to take such evidence without having recourse to the regulation. Nevertheless, the court accepted that there may be some circumstances in which the other state may consider the activity of an expert from another member state as an infringement of its own national sovereignty, in particular where the expert would have to conduct investigations in places connected to the exercise of sovereign powers, or if the expert plans to visit some restricted areas in the other member state. This sounds like a clear-cut division, but in practice there are some problems inherent in this approach, because if we follow the CJEU's reasoning in this regard, then the court in the state of origin has to apply the foreign law, try to devise the point of view of the foreign state, of the requested state in order to ascertain whether the latter state would probably consider the activity of a court-appointed expert from another member state as an infringement of its sovereignty. And only if the court in the state of origin reaches a positive prognosis, it must apply the regulation at all. So I have doubts, I must confess, whether this is really an efficient strategy, because Article 17, paragraph 3, developed precisely a procedure to deal with such concerns. The most, if we stress speed and efficiency, it seems to my mind that the most expeditious way to find out whether another member state would consider an activity of a court-appointed expert from another member state an infringement of its sovereignty, the most simple way to find out whether this is the case would be to ask the other member state, and this is precisely the procedure that is envisioned by Article 73. A subsequent problem arises from the fact that the CJEU does nowhere in its judgments take the Hague Evidence Convention and the history and the conflicts associated with the aerospatial decision into account. So this leaves open the question whether the rather liberal stance of the CJEU with regard to the evidence regulation has an impact on the interpretation of the Hague Convention in the member state as well. If this were the case, then the long-standing conflict between common law and civil law states on the optional or mandatory nature of the convention might eventually subside. On the other hand, the interpretation is possible that the CJEU considers pro-rail as a regionally limited expression of mutual trust between the EU member states only, and that European member states would still cling to a more restrictive stance in applying the evidence convention. I had here now some side glances to the Service Convention, but I skipped these because time is running. I just want to say some words on the impact of new technologies. The issues that I just have discussed are exacerbated when we look at the impact of new technologies, in particular the question of the taking of evidence by video link. A classic example is the Polanski case, decided by the House of Lords in 2005. Here, the English court allowed a French plaintiff, the famous director Roman Polanski, to testify via video link without even mentioning Article 17 of the evidence regulation. This is not an isolated attitude or point of view. In Australia, for instance, the federal court has argued as well that the taking of evidence by video link does in no way interfere with the sovereignty of other member states. But it is questionable, actually, whether such bypassing is actually compatible with the evidence regulation or the Hague Convention. One possible answer to this dilemma would be or would consist in transferring the pro-rail test developed by the CJEU to the taking of evidence by video link. This would mean that permission, either under the convention or the regulation, would only be required if there are actual substantial concerns that the sovereignty of another state may be infringed. An interesting example in this regard is the recent decision by the District Court for the Southern District of New York from December 2015. Here we had another kind of triangular relationship. The US District Court faced the question whether the Bangladesh ambassador to Morocco could be deposed via a video conference without the permission of the Moroccan Ministry of Justice. Morocco is a state party to the Hague Evidence Convention, and in this case, contrary to the decisions by the British House of English House of Lords and the Federal Court of Australia, held that in this specific case, permission was required because the Bangladesh ambassador enjoyed diplomatic immunity in Morocco, and this could not be violated simply by deposing him by way of a video link from New York. Quite an interesting decision. So we see the issues are more difficult than they seem at first. It's not simply a free choice for domestic judges to apply domestic law or have recourse to convention as they see fit, but it's rather a question of balancing various private law, constitutional, party and state interest. In such a complex scenario, it would be welcome if some guidance were offered by elaborated principles, but here we find that so far the approaches differ. In a report from November 2014, the ELI UNIDROIT working group stated that international judicial cooperation within the EU is considered as sufficiently covered by the EU evidence regulation and will therefore not be addressed by the working group, whereas in March 2016, the Council of the Hague Conference actually endorsed developing and drafting a guide to good practice, including soft law instruments such as model rules and model practice notes for courts concerning the use of video link and other modern technologies in the taking of evidence abroad. And in the light what I said before, you will not be surprised that I would rather endorse the more recent approach taken by the Hague Conference. So I now come to my conclusion and outlook. First of all, the discretion of courts in choosing between various options for taking evidence abroad should be guided by adequate principles. In particular, conventions and regulations should not be simply bypassed for the sake of speed or efficiency, but concerns of sovereignty, rights of parties, witnesses, data protection, etc. should be taken into account as well. The elaboration of different sets of principles, European on the one hand, global on the other, should, as far as possible, avoid normative contradictions. This also means that efficient judicial cooperation depends upon a proper coordination between the various institutional actors that I have just mentioned. In sum, a well-designed and intelligently made soft law may well be an important incentive for courts to take treaties and regulations dealing with mutual judicial assistance more seriously than they have been in the past. And this, I think, is a rather optimistic perspective. So happy birthday, UNIDROIT, and thank you for your attention.
Thank you very much indeed, Professor von Hein, for this highly interesting overview of what one could call the coordination issue, coordination problem of the multiple legal sources that exist in this field, and then also your outlook on the use of new technologies. I may just use my prerogative as a chair for a couple of minutes and react. As much as I am tempted to start a discussion on aerospatial and Schlunk and what have you, I will refrain from doing so because I don't think this is neither the place nor the audience. In parenthesis, I actually think they got it right, but parenthesis closed. I wonder if the future and the solution in overcoming all these coordination issues and problems, including the question of the mandatory nature or not, lies not in an increased direct communication between judges. The background to this is, for example, what we have done at the Hague Conference with the International Hague Network of Judges. It was my pleasure many years ago when I joined the Permanent Bureau. My first concrete task was to organize the first judicial seminar ever organized by the Hague Conference. And one of the very tangible outcomes of this seminar was the creation of this Hague network, which was established clearly under the premises of or under the auspices or for the operation of the Hague Child Abduction Convention, which now more and more also involves child protection matters. The network today has more than 100 members from around the world, from I think more than 50 states. At the beginning, I can tell you that in particular from the civil law side, there was certainly a hesitation, maybe even a resistance to join such a network, because it would be counterintuitive for a civil law judge to pick up the phone, send an email, or otherwise ask his or her colleague abroad for either general information about what sort of measures could be taken in the other jurisdiction, for example, accompanying the return of a child, or even more so to discuss real legal issues of the case at hand. And yet, almost 20 years later, we see that this direct judicial communication has really developed a lot, is becoming more and more regular. I shouldn't say the norm, but it's more and more being done. And I wonder if part of the solution, at least, to the problems that you have identified, and you also alluded to them in some ways, is not part of the answer. May I ask you to maybe comment on the future of judicial communication?
I mean, yes, I think you're absolutely right. And given the competence now within the EU for judicial training, there is much more interaction and understanding than there's ever been before, and that can only increase. I just hope that English judges continue to be part of that. But I think, yes, that is part of the future. But I think there's another element that we have to be aware of, and it's how our courts are changing. I mean, I came here today from a conference yesterday in Oxford, and I mean, it is clear, particularly in our context in London, that our courts are really about to embrace technology very quickly. And that's both maybe a good thing, but it's also going to be a challenge. But I think also in the terms of this discussion, it gives us this chance where all our courts will probably start, or are starting already, to do things, to find ways both of communicating and designing new rules that assist access to justice in procedural matters.
Thank you very much.
This one. Oh, thank you. Yeah, I agree, of course. Direct communication between judges is always a good thing, and it may also may be an additional step in solving this problem. But I don't think that these proposals are mutually exclusive. I mean, the focus of my presentation was the contribution of soft law to an efficient and balanced application of regulations and conventions on judicial cooperation. And if you create such principles, if you try to tell judges what would be the best practice in applying regulations or conventions or performing acts of mutual judicial assistance under the domestic law, it may well be that one of these principles would be to, insofar as the legal framework in which they operate allows it, to look for a direct communication with their counterparts in other member states. This is also an issue with regard to the application of foreign law, for instance, and the European Judicial Network, which also tries to increase the direct exchange of information among judges. And this is also something that already has had an impact on practice. I just had a conference in Freiburg last week, which I organized, and we discussed about various methods of determining and applying foreign law before German courts. And a judge from Freiburg just said to me, when he has a problem regarding French law, he just picks up the telephone and calls his French colleague in Colmar. And I think this is a very sensible approach to deal with, at least with simple cases, in a cost-saving and time-saving and cost-efficient manner.
Thank you very much for these reactions. I don't know if we have questions, comments from the floor. Please, Soroi.
In England, yes, in England we've had this for many years in the field of cross-border insolvency. And the very first case, I think, was there was an insolvency administrator in England, and there was the same company or group of companies, a Chapter 11 proceeding in New York. So the English High Court, Mr. Justice Hoffman, the Bankruptcy Court for the Southern District of New York, Judge Tina Brosman, and a protocol was produced, and the judges collaborated in that, and so agreed orders were made on both sides of the Atlantic, and that set a precedent, and it's worked very well ever since. Of course, the key point is there shouldn't be any communication between the judges to which the lawyers are not party. That's rather essential. We can't have a judge just phoning up and saying, what's your view on this? That was the one safeguard, I think.
Thank you very much. If I may just react, that is of course absolutely true, but again, it's common law. There was another case with a cross-border insolvency, US-Canada, which was also common law, kind of less counterintuitive than for some civil law judges. But you're absolutely right, of course, that all this communication has to be handled under a certain protocol, as it were, and this is one of the soft law instruments that the Hague Conference has also produced, which is this the protocol, as it were, or guidelines on direct judicial communication.
Well, that was right, yeah.
Okay. Please, Madam Deputy Secretary General.
Thank you very much to all the panelists and also the chair for a very stimulating panel. I had one of my questions was actually the question that was, well, the comment that was posed by Sir Roy Good. So whether you thought that the experience of the insolvency field, and in particular the debate of whether the solution is that the judges talk to each other and how, or whether you should have hard rules on who decides what, has any bearing on civil procedure in general, so how it should be developed. And my second point is more a comment than a question on the contribution by Professor von Hein. You cited very precisely one of the documents of one of the groups of the ELI UNIDROIT projects. Of course, that's an ongoing project, and therefore, as you rightly point out, the issue is probably not so much as to whether the cooperation is not important or already addressed by existing documents or European instruments, but it's more the scope of the ELI UNIDROIT projects, which as such does not address the issue of judicial cooperation in this way. But the most recent discussions and documents, especially in the service group, I think, and maybe Diane can correct me if I'm wrong, go in the direction of thinking that judicial cooperation should be added to any kind of rules that are developed by the service group, especially when we think of electronic access to justice, for example, electronic service of documents, because of the need that the electronic platforms of the different countries are mutually open, or there must be something that is done at a more general level in this respect. This is both a comment and maybe a question. Thank you very much.
Yep, this is very interesting. Thank you for the update, Professor Veneziano. I fully agree. I mean, this is the sensible way to proceed. Sure.
I mean, I think it also goes, Anna is absolutely right, but I think it also goes back to the point that I made about our group that's working on the obligations of the parties was coming to this point that there's this loyal cooperation between the judge and the parties, etc. And it goes in exactly the same direction, try to achieve that.
Thank you. My name is Luca Vlad. I am an attorney in private practice in private international law. And going forward from what Undersecretary General Veneziano said and Professor von Hein, I have a question for you, namely, which of the three corners of the triangle would you see as the best means of developing one particular aspect in evidence taking and service, which I would call enforcement of evidence taking and of service, namely the situation where the party which is served or the party who is called as a witness does not want or cannot or is not allowed to receive or to receive service of or to give evidence. I've had in my own practice in fact many situations where the differences between national rules in what you can do in terms of compelling service or compelling evidence meant that in fact service and evidence were not achieved, and we had to go back to the original trial with a big hole in the proceedings which could not be filled in the end with the service or with the proper evidence taking. Thank you.
That's a very complex question, because we would have to add another corner, and then it would actually be a quadrangle and not a triangle, because in the EU as well there's an ongoing discussion under which circumstances you may force a party to produce evidence under the Brussels 1 bis regulation under Article 35 by way of provisional and protective measures, and in which way this relates to the evidence regulation. There is another decision by the CJEU on this point, the St. Paul Dairy decision, which is not very clear in delineating between the two instruments. And then there was a later case which was then withdrawn after Advocate General Kokot had delivered her conclusions. So the question is at the moment not conclusively settled by the case law in Europe. But here again, probably it will amount to this issue that we have various options open to the judge under certain circumstances, especially if a party is already in a procedural relationship with the court. It may have recourse to its own domestic law. Under certain other circumstances, parties may apply for provisional and protective measures, and then there's always the possibility, of course, to have recourse to the evidence regulation, which contains some provisions in which the requested state may apply coercive measures provided in the latter state's law. But I did not focus on this aspect here in this presentation, because when it comes to taking of evidence by video link or the direct taking of evidence abroad in general, then it is universally recognized that the requesting state cannot apply coercive measures. So if a witness refuses to cooperate in the taking of evidence by video link, for instance, then the requesting state cannot apply coercive measures, which would then have to be implemented on the territory of foreign states. So here we encounter public international law barriers unless states are willing to accept such an exercise of foreign sovereign rights on their soil. But so far as I can see, the vast majority of states is rather reluctant in this regard.
Yeah, I would take it back even another step in the triangle, which I think is sort of fundamental and interesting from the point of view of the work that UNIDROIT and ELI are doing. Obviously, as lawyers, we all want some sort of certainty, and parties want certainty as well in civil procedure. So are we, in a sense, by developing soft law rules, adding to uncertainty and being more of a nuisance than a help? But I would say in general, I think we are being a help, but it goes even further than that, because what we're trying to do is by putting a soft law guidance or proposition on the table is to maybe encourage a timid legislator to go a bit further if there's something there that we find we can get some momentum and some acceptance behind. So it's a sort of double approach in a way. It doesn't give you an immediate answer, but it's how do we get to a more coherent, holistic cross-border system of justice than we currently have, which is clearly, I would have thought, what most of the entities that have to work across border are looking for. Thank you.
Thank you very much indeed. I'm getting signals that time is up, so unfortunately we can't take any further questions, but I think this very lively exchange has shown first of all, the importance of the topic and the importance for further work and further discussions on various fields. Thinking about the use of new technologies and the question of service by SMS, Facebook, email, and what have you, there is an article entitled Service with a Smiley. I am a smiling chair because I think we have had three very excellent, actually, presentations, thought-provoking presentations. Thank you very much to the audience also for an active participation, and I would kindly invite all of you to give our presenters and also Karin in her absence another round of applause. Thank you very much.